This program is brought to you by Emory University.
Good afternoon, and thank you for letting me present the work that I've been doing on my dissertation so far. Before I begin, I would like to apologize for the change in title. While conducting research, I found another research article that had almost exactly the same title that I had proposed, so I thought it might be better to change it. Today I will be presenting the first chapter of my dissertation, which foregrounds the main arguments that I'm proposing throughout my study, and also gives a general outline of what's to come. So this is the structure of the presentation I'd like to follow today, beginning with the main argument proposed. Then I'll give you a brief introduction of the context of India's diversity and federal framework. And finally, I'll break down my argument into three main blocks. So the aim of this critical legal study is to provide a more nuanced understanding of child, family, and state relations as read within Indian law. While India has an expansive body of law that recognizes the rights of the child and also keeps step with the international child protection discourse, almost every study and report that discusses India's child protection issues critiques its lack of efficiency and failure to implement good legislation. I would like to move beyond this reductive reading of lack of efficiency and provide a deeper and more rigorous analysis of child protection issues in India. So my main argument is as follows. Currently, Indian law acknowledges the primary role of the family in child protection and relegates the role of the state to the background as a guardian of sorts, who is to step in only when the best interest of the child has been threatened. My thesis argues that this acknowledgement is not as cut and dried or ideal as has been presumed. The Indian state has demonstrated a constant ambivalence with respect to its role in child protection. In this context, I use the work of post-colonial third world feminists such as Ratna Kapoor, who speaks about the shifting public-private divide when it comes to areas that affects women's rights. I would like to apply her analysis to the Indian child protection context. So my argument foregrounds two primary factors as causes for the ambivalence demonstrated by the Indian state. One is the personal law framework, and the second is poverty. And while seeking to argue that the acknowledgement is not ideal, I interrogate the overemphasis on a rights discourse in the protection of children that does not shed its overlying assumptions about autonomy, capacity, and individualism. And I seek to employ ecogenerism and vulnerability to create an argument that a more nuanced understanding of children's environment is critical and that the state needs to step out of the shadows and examine its own ambivalence. So a word about India's diversity. Disclaimers about India's diversity are always necessary for any Indian scholar who is trying to engage with subjects in the Indian context. Acknowledging all this diversity, so there's geographical diversity where India has 29 states and 7 union territories, which are mainly divided on the basis of language. There is also plenty of religious diversity. 80% of India's population consists of Hindus, 13.4% Muslims, and the remaining 6 to 7% are Buddhists, Jains, Sikhs, Christians. I think the most popular statement signifying India's religious diversity was when prior to this current government, we had a Hindu president, a Muslim vice president, a Sikh prime minister, and a Christian chairperson of the ruling coalition. So apart from the religious, geographical, and linguistic diversity, we also have a lot of socio-economic diversity. So a walk on any street in an Indian city, you will see children wearing expensive uniforms, carrying expensive fashionable backpacks, getting into cars, or going in nice school buses to private schools. You will also see children wearing hand-me-down or torn and dirty uniforms, running to get onto an overcrowded municipal transport bus, trying to get to public school. And you will also see infants being carried in the arms of adults, knocking on doors of cars, begging for some money. So acknowledging the extent of this diversity, my study focuses on a purely conceptual understanding of child, family, and state relations as read within Indian law, and especially as within central law. So the Indian federal framework that can be seen in the Constitution of India adopted post-independence in 1950 tends towards centralization within a federal pattern and framework. This means that the union government or central law plays a more dominant role than the laws of the different states. The following two slides discuss child abuse in the Indian context, and I've put up some statistics related to the issue. Studies on child protection in India generally differentiate between societal forms of abuse and intrafamilial abuse and neglect. For the purposes of my study, I would like to look at the two categories in conjunction with each other and not as separate. One, because most of the actors in both categories generally overlap, and second, also because separation perpetuates the reasoning that intrafamilial abuse and neglect occurs or is completely sequestered from societal causes, and that societal abuse occurs in isolation from a normative understanding of child, family, and state. Getting back to the main argument, so personal law. Getting back to the main argument, so the current understanding is that the primary role in child protection is played by the family and the state merely acts as a guardian. My argument is that this understanding is not as cut and dried as is presumed. The Indian state has demonstrated a constant ambivalence, and this is due to the channeling effect of the personal law framework and child and family poverty. This understanding is not ideal either, and then I will talk a little bit about the theoretical frameworks that I will be employing. So, what is personal law? Family laws in India, that is laws governing marriage, inheritance, succession, adoption, etc., do not consist of a set of uniform laws governing all Indian citizens equally, but are a set of laws that govern according to the personal religious laws of different citizens. For example, two Hindus will be married as per the Hindu Marriage Act of 1955, and two Muslims wanting to get married will be married as per Sharia law. The government and the courts have generally shied away from interfering with the personal affairs of communities. But it cannot be denied that the legislature has enacted and the courts have enforced certain laws that delegitimize social and traditional practices that violate basic human rights principles. However, I would like to argue that this separation of family laws as personal religious laws that are not to be interfered with promotes themes of family privacy and sanctity and allows the state only a limited role in child protection, which it exercises inconsistently. And these themes of family privacy and sanctity can be traced through the very history of the separation of family laws as personal laws. So prior to British colonization and British rule, populations in India govern themselves using indigenous legal systems. However, after the onset of British colonial rule, the British brought in structures and codes that were influenced or inspired by their experience in the West. This experience was not extended to civil or family laws or systems governing marriage, inheritance, etc. Research has shown that this is mainly due to three factors. One, that for the British themselves, religion and family were considered to be separate, and this can be seen from their separation of secular and ecclesiastical courts at the time. The second is that they were keen to quell any religious protest against their rule. And the third is that personal religious law was not really relevant to their economic interests in India. Gradually, the economic mission of the British Empire evolved into a civilizing mission. And at the same time, there were a number of Indian social reformers who came up, eager to prove India's civilizational maturity and prove their ability to self-rule. They reformed a number of practices such as sati, which is widow self-immolation, passed laws allowing for widow remarriage, raised the age of consent for child marriages, etc. However, this did not result in a uniform set of laws governing family practices, and this is because they had to contend with the opposition of political nationalists or cultural revivalists who wanted to separate the family or the home, translation, women and children, as private, separate from colonial legal intervention, and something that needed to be protected from that legal intervention. Thus, a strict public-private divide mostly came about as a site for Indian resistance to colonial rule. I seek to understand the channeling effect of the historical and current context of this framework mainly through three practices: child marriage, female feticide, and honor killings, practices that are still prevalent in India today, and also understand how these affect a child-centered understanding of children's needs and rights, what the role of the state is in mediating tensions between competing rights, and what implications this may have for an effective child protection strategy. However, my argument should not be construed as an argument in favor of a uniform civil code to govern family law in India. While the state must understand the effect that sustaining a separate family law system has on child protection, it must also understand that it is not necessary to break down this system, but to work within it. Moving on to child and family poverty. This factor also profoundly affects the child protection discourse in India and impacts the understanding of child, family, and state relations. If, as professed, Indian law acknowledges the primary role of the family and relegates the role of the state to the background, this normativity is turned on its head when confronted with child and family poverty. In this context, the state acts in two ways. First, it may either overlook the situation of the child and the family completely and allow the child to grow in circumstances that may not necessarily be in her best interest, or second, it simply swoops in, removes the child and places him or her in an institution without discerning the needs of the child and the family and how they might be best met without removal. Thus, poverty, as I see it, is a second tier of negotiation, the personal law framework being the first, that the state must interrogate in examining its ambivalence towards child protection. Literature has generally analyzed the impact of poverty in terms of education, labor, health and mortality of children, but there has been no engagement with poverty in terms of child, family and state relations. This creates two critical areas that have been left unexamined. One, that differing situations of poverty impact what can be construed as abuse and neglect within the home. For example, in the United States, a child may come under the watchful eye of Child Protective Services for not living with adequate sleeping arrangements or living in unhygienic and unhealthy living conditions. However, nearly 17.4% of India's population, urban population, lives in slums, which are defined as one-room, cramped, poorly ventilated and dirty households, generally with a married couple, extended family members, and a number of children in the same house. If children were to be removed for the same reasons as they are in the United States, there would be an astounding number of children living in state care. The second critical area is how the state deals with situations of abuse and neglect. Just last year, I went to India for a research trip where I attended the hearings of the Child Welfare Committee in Bangalore. The Child Welfare Committee is a quasi-judicial body that was set up by the Juvenile Justice Act of 2000, and it deals with children in need of care and protection. During my time there, I attended a hearing of a young boy. He must not have been more than 6 or 7 years old. He had been rescued from the street because he had been living with his parents on the street. The parents had come to the Child Welfare Committee to claim the child back from the institution and take him back, and they said that they would get a house and live, send the child to school, etc. However, the Child Welfare Committee refused to send the child back with the parents. They asked, one positive factor that I noticed was that they asked the child for his opinion in whether he wanted to go back or not, and he said no. But there were a number of factors about this that bothered me. One, that neither the child nor the family were given any representation in front of this quasi-judicial body. Second is that assumptions had been made without any real proof, as a statement by one of the committee members to me as an aside proved, and I quote, "The parents are going to take him back to the streets only. The father seems like an alcoholic. It is better the child remains in the institution." This assumption led to no real engagement with the child or his family, and it was assumed that the child's family was no good, incapable of change, and that the child would do much better in an institution run by the state where his situation without counseling, medical facilities, or education seems unlikely to change. Observing this particular proceeding made me question the ambiguity of the state in dealing with the protection of the child. While on the one hand, there are programs like the Integrated Child Protection Scheme and the Integrated Child Development Scheme that speak of an integrated approach to child development and well-being, the same integrated approach or child-centered approach is forgotten when dealing with children in terms of their engagement with law and judiciary. As soon as the child is brought into the system, there is no indication of these programs ever having been in the works. Thus, I seek to argue that the state has yet to engage with poverty properly in the context of abuse and neglect, and delimiting poverty as a framework that affects the relationships between child, family, and state would enable a thorough review of the state's ambiguity, eventually leading to a more integrated approach to the protection of the child. Finally, in the context of the second part of my argument that the current understanding of child, family, and state relations is not ideal, I seek to explore three main theoretical frameworks. Recently, there have been emerging critiques of the United Nations Convention on the Rights of the Child based on an understanding that it promotes a Eurocentric and Western normative ideal of childhood and fails to recognize the cultural and everyday lives of children living in non-Western contexts. In light of this critique, a call for an emphasis on the social and historical constructs of childhood, now popularly termed as multiple childhoods, has developed that recognizes childhood as embedded in local and cultural constructions. While acknowledging that this paradigm supports my argument to delimit personal law and poverty as broader frameworks impacting child protection, I reject it for the following reasons. One, that it postulates a very limited reading of the Convention on the Rights of the Child. Second, that its critique of a Western ideal of childhood does not really hold ground in context of abuse and neglect and protection of the child. And third, and this is a critique raised by Sayali Bapat, that this paradigm reads culture in third world countries as static and reinforces third world childhoods as the other, which is present but undesirable. Thus, I seek to look at other theoretical frameworks that go beyond this cultural analysis of children's rights and that advance my arguments. The first is ecogenerism. Ecogenerism is an ecological theory of childhood first developed by Professor Woodhouse, grounded in the concept of generism, which places the child at the center of inquiry. Ecogenerism digs deeper and places the child at the center of 4 different systems: microsystems, mesosystems, exosystems, and macrosystems. So microsystems are the relationships that directly affect the life of the child, including the family, the peer group, neighborhood, school, etc. Overlapping microsystems are mesosystems. Exosystems are those relationships that touch the life of the child indirectly, such as those of the parents' workplace, the labor market, etc. And the final layer that incorporates all of these is the macro system, which is a larger collective of politics, economics, and religion. Law and all of its various sources, according to the ecogenerist theory, have been recognized as a product of the macro system, and it funnels all of its dominant values and power relations through the entire ecosystem. I use this theoretical framework to augment my argument that personal law and poverty need to be examined as broader frameworks or macro systems, which would help us to go beyond competing rights and tie together the different systems that are right for the developing child. I also believe, and through my discussion with Professor Woodhouse, that this theory integrates the concept of multiple childhoods and allows for a less conflicted consolidation of different laws and policies that affect the developing child. The second paradigm I seek to engage with is the vulnerability paradigm, which has been developed by Professor Feynman. Though this paradigm admittedly is fashioned for an American audience and seeks to rework concepts of equality and autonomy in the American context, I believe that its critique of the autonomous liberal subject and the separation of the public and private spheres, along with its call for a more responsive state, can have a resounding impact on current child protection law and policy in India. Sayali Bapat, in her analysis of literature on children's rights, concludes that most academic work, as does liberal theory, comes with an underlying assumption that the capacity to exercise rights is self-evident to people across the globe. I argue that though children are central to their process of development and are capable of participating in decisions related to their lives, they may not necessarily have been enabled to exercise or assert rights that are guaranteed to them by law and policy. For example, if you take the Prohibition of Child Marriage Act that was passed in India in 2006, it allows for child marriages to be voidable at the instance of the contracting party, or in case the contracting party continues to be a minor, the guardian can take the matter to court. However, a question arises how whether the child or whether the minor contracting party, even upon attaining majority, is really able to exercise a true and informed choice of whether he or she wants to continue with the marriage, especially in the context of the personal law framework that we saw here today. In the paradigm's questioning of legal subjects being competent and autonomous, and for the purposes of my argument that the state understand and better define its role in child protection, becoming more responsive to families, I find the vulnerability frame to be a critical framework. While any call for an increased state intervention immediately arouses suspicion, especially in the context of lived realities in India that include corruption, abuse of power, top-down models of lawmaking, which are critiqued primarily as unparticipatory and a colonial legacy, it is important to note that the vulnerability paradigm calls for a more responsive state, one that is attuned to the vulnerabilities of individuals, and which, according to Professor Feynman, accepts a certain amount of responsibility towards the institutions it creates, legitimates, and maintains. Employing both the ecogenerism and the vulnerability paradigms also fits perfectly within the Indian post-colonial context. The universal principles created by liberalism, namely equality, justice, and freedom, have never easily translated into the Indian context. Both post-colonial theory and post-colonial feminism question many features of the liberal project. And this has been well elaborated by Professor Ratna Kapoor in her work. First, both question Eurocentric narratives of history that claim the world has emerged from an uncivilized era and is on its way to an evolved civilization. Second, they question assumptions about the other that have been created, and these assumptions continue to prevail in the present time, and it also questions the autonomous liberal subject. I believe that both the vulnerability and ecogenerous paradigms, individually and together, deftly weave together and seek to resolve the questions raised by post-colonial theory. While post-colonial theory raises important questions in the Indian context, ecogenerism and vulnerability allow the observer a constructive space to acknowledge ambiguities and work within specific contexts, creating a viable alternative vision of law as a social justice strategy. Thank you. I'd be happy to receive any comments or questions anyone may have.
I think, thank you. It's a terrific chapter. So,
Thank you.
But I also think that the vulnerability theory, two things that you didn't emphasize that I think you might find helpful. One is that it takes a life course perspective. So one of the problems with the liberal legal subject is that it only takes one part of the life cycle to focus on, the part where the legal subject is the least vulnerable, right? And it focuses, or at least apparently vulnerable, and it focuses on that, where when you take the life course perspective, what it does is to pull the child into consideration in relation to the state in a way that the child is not in relation to the state in normal liberal legal theory, which relies heavily on this notion of capacity and consent, and the child is considered not to have that. So that's, I think you might develop that a little. The second thing is the idea of resilience, and how resilience is where you hang the notion of state responsiveness, so that it's none of us are born resilient. It's something that's acquired, and of course a big function of childhood is the accumulation of resources that give us resilience, that give us the ability to act and to survive and to make choices and to options. In fact, you can think of resilience, you can think of that as gaining the ability to act autonomously, right? And when you start to look at it that way, resilience and state responsibility, the state has an active responsibility to see that children have access to the institutions that give them resilience. So that is the basis for the state intervention. And it's a kind of a model that moves away from the model that dominates in the American system, and I think also in many systems, and that is that the parents have a primary right in regard to children, and it begins to fashion this more as a shared responsibility of both parents and children. And there's a couple of things that I can give you to read that I think might actually help a little with this, but it's really just moving away from the idea of capacity in regard to, moving away from the idea of rights as we normally think of it, as something that, is exercised by this fully autonomous, independent, self-sufficient liberal legal subject, moving away from that as the basis to this notion of the over the course of the life course, the right of the child to have access to the institutions that will eventually allow the child to act as a full participating member of society. And so we can talk about that some more if you want, but it's a great paper, and I really think you're doing a great job.
Thank you. Thank you for those comments, and for this is going to be really helpful when I'm doing my chapter on vulnerability. So thank you.
Yeah.
Well, I've enjoyed very much reading your draft and commenting on it, and seeing how you worked through various issues, and see you plotting your way forward. I thought that part of what Martha was saying was very true, also sort of links the vulnerability theory with the CRC, because the CRC makes it clear that, the Children's Rights Convention makes it clear that the state has a duty to provide not only assistance to the child, but assistance to the parents of the child in meeting their. It would, if you really applied the CRC, the case you talked about in the that appalled you in the child who was taken off of the street, and the parents were told to go back to the street, we'll keep the child. The state was failing in its responsibility under the CRC or in vulnerability theory, or in it was, if you were going to use eco-generous theory, it was looking at the child as just this in isolation, completely in isolation from all the systems that affect the child. So I like the idea of putting all these using these as different ways of critiquing and viewing. And I'll keep on thinking about it. I was wondering though, what you thought they should have done with the child, with that boy that was. You said that there was a set of programs that were supposed to be mobilized in order to meet the needs of the families in a kind of a community context.
Right.
I was a little confused. Were those just sort of on paper and not actually implemented, or was it they were implemented in a general setting but not in the child abuse setting?
So I guess my answer to that question would be both situations take place, because there are some areas where these schemes are not implemented or probably never even heard of, whereas they're trying to be implemented progressively. So there is a certain amount of implementation elsewhere. But the way I was using the programs in the context of this chapter was that the members of the Child Welfare Committee did not seem to have any idea of these schemes being in existence, or that they can use any of the resources or funding from that scheme to help integrate that family. And also, so for example, the Integrated Child Development Scheme has Anganwadi centers that are set up throughout, that are supposed to be set up throughout, which help take care of children between the age of 0 to 6. And they're supposed to provide early childhood education, care. They also help young mothers with different things such as breastfeeding or talking about taking care of children. They are also platforms where children can be, like daycare platforms where children can be left when the mothers have to go to work. So there are all these different things that are in place and that are being progressively implemented, but it's taking way too much time. And also the fact that quasi-judicial bodies have no ideas or no idea of these schemes, and they don't seem to be taking them very seriously in the context of their role. They just seem to work within a binary choice. So either you send the child back home and get the parents to promise that they will provide some education, or they will send the child to school, or you keep the child in the institution. Okay. And that's what I've been trying to work through with this.
Yes. Another thing about vulnerability theory that might help you is that institutions themselves must also be considered vulnerable. And you mentioned the corruption in the government already, but I would really urge you to look at what are the vulnerabilities, why are the institutions like this council responding the way that they are. So what are the problems, so that you can understand the difficulties that the institutions, because it sounds to me like there's already been some recognition of state responsibility. But so they've begun to, but there are reasons why that's not being implemented fully. And I think in order to have your story really comprehensively fleshed out in a way that's going to be useful you have to look at those vulnerabilities of the institutions too. So it's not only the individuals, and including the vulnerabilities of the state, right? Which might be budgetary in addition to the fact that there's corruption or something like that. But so so I would urge you to do that, to look at those institutions.
I'm actually planning to go in. So where I speak about the vulnerabilities of the institutions is I don't think I put it in clearly here.
Yeah.
But where I speak about the abuse of power, corruption, etc. So that will form one part of my argument when I speak of vulnerability.
But when you talk about the vulnerabilities of the institutions, it should not only be in terms of
broader state.
Negative.
Okay.
I think it's really very powerful when you can look sympathetically at the position of the institutions or those commissioners, and understand how you can help them. Or how a vulnerability analysis, how your analysis of what's going on can actually help them do a better job,
right.
And not just be critical, but be constructive in the way that you approach the vulnerability. So I would urge you to do that.
And to that point, I also have one strong belief about the Indian context and why vulnerability would be more easily accepted in that context is because to a certain extent it already is. India's already acknowledged its role in being a socialist or in being a welfare state. So it won't be maybe it'll be more readily accepted in the Indian context as well. So.
I found it very interesting, and one of the things that caught my attention was your mention of the public-private divide and how sort of keeping the family a private space was really a push that came from civil society and sort of a reaction to colonialism and the drive for independence. And so I'm just wondering whether that's an area that you will be exploring in other chapters, and would you say that that sort of private space is getting smaller, and is civil society playing a role in terms of really calling for the private family to be opened up in cases where there's child abuse in order to protect children?
Thank you, Atiana, for a question. So I'm basically looking at the public-private divide in the context of my chapter on the personal law framework. What I am mainly examining is part of your question about whether the private divide is, whether the private space is being opened up, and I'm examining it through the courts and the legislature, where they are trying to enforce legislation to delegitimize certain social and traditional practices. In terms, what my chapter seeks to argue is that what they are doing seems to be isolated from the channeling effect this has in civil society, on the channeling effect of family law on civil society. So that if you continue to have this separation of personal religious law, it sustains this public-private divide. And so where you're giving, on the one hand, some people can argue that any law that is passed may be an interference, or then it may also have an effect where people don't take something seriously, because according to them, then the family remains that private space. So that is one of the main reasons that I argue as to why there is ineffective child protection in India, despite the presence of so many laws.
I have a question. Just now you mentioned the primary rule is child protection. I want to know something in the practice. I mean the implementation of the child protected rules. Because in China, usually we have a problem because according to the traditional ideology, family is an autonomous, independent circle. So the state power is not expected to involve it. So this, of course, we have changed so much, but still this traditional ideology still influence people in various ways. So in our practice, if there is a judgment, for instance, a judgment for custody, the fundamental court are not reluctant to enforce it because it's a family affair. So they don't think they involve it to separate the child from one of the parents. is there by you a similar question? I mean, so I want to know the implementation of the child protective rules.
I'm sorry, I'm not sure if I got the question correctly. So when you speak of custody, which custody are you talking about in the context of the family
custody
courts?
is only an example. I mean, the protect the child means to some extent the intervention of the state power
Right.
to the family. Is there some problem in the practice? Some resistance from the
So, there have been certain cases where, for instance, reporting of child sexual abuse. So, when these cases come up, sometimes at the level of the police itself, the case is shut and they are told. There's actually a great report called "Breaking the Silence" by Human Rights Watch, and that speaks about the implementation of the recent Protection of Children from Sexual Offences Act, where and the report has enumerated some cases where the police have just told the family or the parents of the child who have actually come up and reported child sexual abuse, and said that this is a family affair. You don't want to ruin the reputation of your child. How will she get married? So I mean, if anyone comes to know that she's been sexually abused, how will she get married? So at the level, so in this sense, there have been those implementation problems. On the other hand, there have also been problems with respect to people not reporting certain instances of abuse to the police, either because they know that they will be sent back home without a first information report being filed, or that they don't want to report it themselves because they feel that this is a family affair and that should stay within the family.
Okay. The second question is that is India a member state of the Hague Convention on the Civil Abduction of Children?
No, not yet.
Because of this? Because of the above-mentioned reason? I mean, the implementation problem, or because of other considerations?
So, so civil abduction would be that's not a part of my thesis, but I did do some research on that for a paper I did previously, and India is not a party to that for various reasons. But Indian courts have, in those cases, have generally tended towards to give decisions on the basis of the best interest of the child, and have spoken of the best interest in terms of where the child's interests would be best met with which parent, so and in which country. And it's not really been cases where they haven't really done that because they want to acknowledge the primacy of Indian law, but they always tend to focus on the best interests of the child. But no, it is not a party to the.
Thank you.
Where's the other? Okay.
I have a curious question. So, your dissertation mainly focused on the India domestic laws and make suggestions maybe to the legislators and the government. Is that right?
I'm hoping that it will be used by different legislative bodies, or even there's a lot of activism in the non-profit sector, and they advise the government on laws that are to be passed. So I'm hoping that this may be used in that context, and also that my use of the eco-generalist and vulnerability theory may have implications even outside of India. So I hope for that to happen. Okay, I guess there are no more questions. So thank you so much for being patient.
Thank you.
Thank you.